Hello and welcome you all. So today we are breaking down the constitutional amendment process, what it is, why it matters, and how it can change all laws. So let's get started. It is mentioned in Article 368 of Part 20th of the Indian Constitution. This procedure ensured the superiority of the Constitution with a strong check on the arbitrary actions of the Parliament. During the discussion in Constituent Assembly on this aspect, some members were in favor of adopting an easier mode of amending procedure for the initial 5 to 10 years. Initially, it was on temporary basis, and Pandit Jawaharlal Nehru was also in favor of the constitutional amendment process because it wants the flexibility of constitutional laws due to the dynamic nature of Indian territory. The Constitution provides for a variety in the amending process. This feature has been commended by Australian academic Sir Kenneth Weir, who felt that uniformity in the amending process imposed quite unnecessary restrictions upon the amending of a parts of the Constitution. The original Constitution provided for the three categories of amendments. The first category of amendments are those contemplated in following articles. These amendments can be effected by the Parliament by a simple majority such as that required for passing of an ordinary law. The first category is simple majority. Some provisions in the Indian Constitution can be amended by a simple majority, means 50% of the member present and voting in the House. It is to be noted that these amendments fall outside the purview of the Article 368. It is not considered in this article. The first category of the amendments are those contemplated in Articles 4, the Clause 2, Article 169, 239A Clause 2, 239AA 7B Clause, 243M 4B Clause, 243ZC 3rd Clause, and further, and the Para 21 of Clause 2 of the Schedule 6th. In the second clause of the Article 4, no such law mentioned in Article 2 and Article 3 as aforesaid shall be deemed to be an amendment of this Constitution for the purpose of the Article 368. Now, what is Article 2 and 3? It is altering name change of the states and further. Article 169, abolition of creation of the legislative council in the state. It is also can be amended by a simple majority. Article 239A Clause 2, when a body is elected or established as aforesaid in relation to any matter with respect to which the Legislative Assembly of the Union Territory has power to make laws, being constructed as including a reference to the Lieutenant Government acting on the advice of the ministers. Now, the second category is constitutional amendment by special majority. Major provisions in the Constitution can be amended only by a special majority, which means the 50% of the total membership of the House and a majority of two-thirds of the members of that House present and voting. These are some major provisions that can be amended by the special majority are Fundamental Rights, Article 12 to 35, the Directive Principle of State Policy, DPSP is Article 36 to 51, all other provisions that are not covered by the first and third categories. Third category is the constitutional amendment by special majority with a state considerations. Certain constitutional amendments require ratification by at least half of the state legislatures. These are amendments that affect the federal structure. The election of the president, change affecting the election procedure of the president of India, the amendments that alter the extent of the executive power of the union and the states, the legislative powers, changes in the distribution of the legislative powers between the union and the states, amending related to the Supreme Court and High Courts, including their jurisdictions and powers, and representation of states in the parliament. Constitutional amendment procedure itself cannot be amended without the special majority and a half of the state ratifications. And further, the fifth and sixth schedules, amendments affecting the provisions of the fifth schedule, which deal with the administration of the scheduled areas and scheduled tribes, and the sixth schedule, which deals with the administration of the tribal areas in the states of the Assam, Meghalaya, Tripura, and Mizoram. Now let's discuss the procedure of the amendment of the Constitution under Article 368. In this, a bill for the amendment of the Constitution can be introduced only in either house of the Parliament, not in the state legislatures. The bill can be introduced either by a minister or by a private member and does not require prior permission of the president. The bill must be passed in each house by a special majority, that is, a majority more than 50% of the total membership of the house, and a majority of two-thirds of the members of the house present and voting. Each house must pass the bill separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for deliberation and passage of the bill. If the bill seeks to amend the federal provision of the Constitution, it must also be ratified by the legislature of the half of the states by a simple majority, that is, a majority of members of the House presenting and voting, as we have studied earlier. After duly passed by the both houses of the parliament and ratified by the state legislature, where necessary, the bill is presented to the president for his her assent. The president must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for the reconsideration by the parliament. After the president assent, the bill becomes an act. So, friends, this is all about the constitutional amendment process. If you want to solve the MCQs related to this chapter, you can join our Telegram channel. The link has been provided in the description box.